Welcome everybody to the third installment of Coffee Time with Robin Appleby. We're really excited to kick off a three-part series today about getting employees back to the workplace. So in our first part, which we'll have today, we're going to talk about employers' obligations in respect of employee safety at the workplace. The second part will be how does an employer protect its workplace by screening employees for COVID-19. And the third part will be how to deal with employees who refuse to come back to work or refuse to follow the policies that an employer puts into place. So I want to introduce my fellow Robin Appleby lawyers. Charlie, how are you?
Hey, Jonathan.
Ismail, how are you doing?
Pretty good, Jonathan.
Nathan, great to see you.
You as well.
Okay, so Charlie, what obligations and liabilities does an employer have to employees to bring them back to the workplace safely?
So first of all, Ontario appears to be moving in the right direction with the trend of reduced daily reports of new COVID-19 cases. But COVID-19 continues to pose challenges for employers as they look to transition their employees back to the workplace. So broadly speaking, employers have a duty to protect the health and safety of their employees, and the failure to ensure a safe workplace could lead to liability under different statutes and common law. But for the purpose of our discussion today, I do want to focus on Occupational Health and Safety Act. And under this act, an employer is required to take every precaution reasonable in the circumstances for the protection of a worker. So the question is, what is reasonable? This is really a business-specific question, and an employer should conduct a workplace hazard assessment to determine the appropriate precaution. The employer needs to understand the risk that they're trying to mitigate and make sure that they can implement appropriate measures before calling everyone back to work. They should also get the most up-to-date information on COVID-19 preparedness, both from a federal and provincial government and health authorities, as well as other credible sources.
And I'll just interject there, Charlie, with a thought. So as we were preparing for this, I wondered about employers where their workplace has common areas or the workplace itself is a shared space with other businesses. And these spaces may be managed by third parties such as landlords. So the question I thought of was what employers' obligations are in respect of these areas. So unfortunately, the answer isn't clear. So we kind of need to draw guidance from the broad nature of the employer's obligations under the Act. So the obligation of an employer to take every reasonable precaution in the circumstances for the protection of a worker has been called a sweeping duty because there's no prescribed conduct in the Act, and the required conduct may actually vary by workplace. Likewise, the definition of workplace under the Act is broad as well. So it includes, for example, areas that are near where an employee works, not necessarily the workplace only. So it's a very broad and contextual assessment. And while the employer obviously cannot control the actions of third parties, there may be an obligation on the employer to take all reasonable steps at its disposal to influence those third parties, such as if the employer sees that there's no hand sanitization centers in the lobby, or people aren't social distancing in elevators, then they might have to raise this with the landlord to protect their own employees.
Right, so that's a really good point. Thank you for that. So now that we've had the employer's perspective, I'll briefly chat about the employee's perspective. So the Occupational Health and Safety Act also provides the worker with the right to refuse to work where they have a reasonable basis to believe that the performance of their job duties presents a danger to their health or safety. That being said, this isn't a right that's merely exercisable in the sole discretion of an employee. So it's true that the employer needs to provide a safe environment, but at the same time, employees just can't refuse to work on the basis that they feel unsafe if the safety is not even an issue. So on our next episode of Coffee Time, we'll have that discussion about the employer's rights and circumstances where the employee refuses to return to work without any legitimate basis. So there is a process to be followed by an employee who refuses to return to work. The employee first informs the employer, who does an assessment and addresses the issue if necessary. And if that issue persists, then the Minister of Labor gets involved to inspect and make recommendation. Whether or not the employee's belief regarding the safety of the workplace is reasonable will depend in part on the nature of the workplace, the employee's individual circumstances, and publicly available information with respect to COVID-19 at the time that the employee is called back to the workplace. It is important to note that under Occupational Health and Safety Act, no employer or any person acting on behalf of the employer can discipline, suspend, or dismiss a worker or impose any penalties on a worker for exercising their rights under the Occupational Health and Safety Act.
All right, so we know that employers have a potential obligation, or they have an obligation and potential liability. And we know that employees could refuse unsafe work. So what steps could an employer take to meet their obligation and to mitigate their liability?
Right, so workplace policies and practices needs to be developed, updated, and supplemented to address the workplace health and safety issues and to address specifically the issues related to return to work. There are practical considerations like commuting to work, accessing facility space, or the use of common areas that either spur the need for these policies or inform these policies. So the employer should really ensure that they have appropriate measures in place to address all the items that are being discussed here today. That these policies and practices need to be tailored for each business and their specific industry. But generally speaking, the broader categories may include sanitization, cleaning, social distancing measures within the office, testing, screening employees for potential COVID-19 infection, and the use of PPE. And the point of these policies is for really the employers to comply with their legal obligations and to also mandate the employees to take appropriate steps to assist the employers in maintaining a safe workplace. And the failure to comply with these policies may also form the basis for a disciplinary action against a non-compliant employee.
Okay, so these policies sound like they're very broad and they're applicable to the workplace generally, and they're really about accommodating or dealing with the average worker. So rather than trying to account for exceptions, is that correct?
Yeah, Jonathan, you're exactly right. There really is no one-size-fits-all policy that the employers can implement or come up with. However, there may be policies which address the process for dealing with a more focused and individualized responses to COVID-19 related issues and returning to the workplace. These exceptions may need to be addressed for some legal reasons, such as obligations under the human rights law, or for non-legal reasons, such as maintaining workplace culture.
So Ismail, as employees go back to work, should we expect more individual accommodation requests?
Yeah, we definitely should expect that. COVID has had a broad range of impacts on the population, and there's going to be more people who are going to request to work from home. Off the top of my head, there's 3 reasons that employees will likely use as justification to allow them to work from home. The first being that they currently have COVID-19 symptoms. This includes individuals that might have extended healthcare issues due to previously contracting the virus. The second being individuals that are high risk due to their age or individuals with weakened immune systems. And the third is individuals that have home care obligations, such as taking care of their children or sick relatives.
All right, so we have generalized policies, we have individual accommodations. So how does an employer who's clearly trying to create a large workplace with generalized policies prepare for individual requests for accommodation?
Well, as Charlie mentioned, employers need to think about potential scenarios ahead of time and try to address these scenarios through policies. But we all know that policies will not cover all possible outcomes. As a practical consideration, employers should create a mechanism for employees to request accommodation. This process should allow the collection of only the required information, as employee privacy also has to be respected. The questionnaires that are on government websites are likely a good start to developing your own request for accommodation forms. Once you receive a request for accommodation, the obligation under the Human Rights Code is to treat everyone equally in the employment context. When the duty to accommodate is triggered, it is the employer that has the obligation to determine how the employee can be accommodated to the changes in the workplace or through working conditions. The code also requires that each request should be evaluated on a case-by-case basis. Thus, it is important to remember that there is no one single solution that fits all the scenarios.
All right, so I'm an employer. I want to accommodate people, but how do I know? So when is an accommodation trigger?
The burden is on the requester. In this case, the employee, to show that they have a case for discrimination. They can do this by showing that they have a protected characteristic, that there's some adverse impact in the employment context, and that the protected characteristic is a factor in the adverse impact. It does not need to be the motivation or the main reason, simply needs to be a factor. So where an employee is sick as a result of COVID, the test for accommodation will be met quite easily. But there is more complexity when the employee is requesting accommodation to take care of a family member.
Nathan, you recently looked into this situation. So what's a test in such circumstances in terms of when we have to accommodate?
Yeah, so for family status, unfortunately, the test is unclear. So for many years, the established test in the context of childcare, at least, was a test from the case called Johnstone, which was a federal court of appeal decision, which was subsequently adopted in Ontario. In that case, the test that's established required, among other things, that the employee complainant show that there's a legal responsibility to provide the care, as opposed to a personal preference. So we're dealing with individual parents that have to take care of their own child, as opposed to an individual maybe taking care of a friend's child. And then the employee also had to show that they took steps to self-accommodate by seeking out other options for obtaining care. So for example, by asking a grandparent to provide the care to their child, or moving to a new care center if the issue was that the work hours didn't align with the hours of operation of the care center that they were currently at. However, the tribunal has recently rejected this test and said that the test for proving a prima facie case of discrimination should be the same as for other grounds, as Ishmael set out previously, with some minor nuances. So specifically, the tribunal rejected that there had to be a legal responsibility to provide the care, because this is not always a clear delineation of legal responsibility, for example, with elder care and adult children taking care of their parents. And the tribunal also rejected an obligation to self-accommodate. So rather, the availability of alternative measures for care is part of the assessment of the disadvantage to the employee, which must be shown to be a real disadvantage rather than a negative impact. But more recent case law and tribunal decisions have unfortunately not said which test is the actual test in Ontario, so we're kind of left with two parallel tests. That being said, the tribunal has shown that it may take a different approach than Johnstone, at least in the context of elder care, and employers may be well advised to consider claims more contextually before dismissing accommodation requests. This is especially in the context of COVID, where we may see elderly individuals have more prolonged health consequences as a result of having contracted COVID compared to younger people. So we may see more adult children taking care of their parents. And in the fall, we may see that many students don't go back to full-time in-person instruction, which may leave parents scrambling to find care solutions for their children.
All right, so we know that the Ontario Human Rights Code protects people from discrimination if they're part of a protected group. Nathan showed us how family status is a protected group. So Ismail, if employees establish an employer must accommodate them, like to what end, like to what extent does an employer, how much effort does an employer have to do to accommodate an employee?
That's a very good question, Jonathan. If accommodation is required, the employer must accommodate the employee to the extent that the accommodation is reasonable or short of undue hardship. Now, the question of undue hardship is difficult, and it's determined on a case-by-case basis. The Ontario Human Rights Tribunal has considered three factors in the assessment of undue hardship. They'll look at cost. Financial costs such as capital, operating, and restructuring costs are examples of costs which may be direct results of the accommodation. They'll look at outside sources of financing. Both the employer and the employee have an obligation to look at outside sources to assist with cost of accommodation. So an example of this could include government programs and funding that may be available. The last is overall health and safety risk. The tribunal is going to look at the level of risk the accommodation poses to other workers, where if the risk is higher, there's likely going to be a requirement for more accommodation. Since COVID is so dangerous, this part of the test will likely be triggered in many circumstances. When thinking about potential jobs, such as sales, retail, construction, there's going to be more issues for accommodation beyond simply allowing employees to work from home. But in most other cases, allowing individuals to work from home would likely be seen as a viable option.
So what do we take away from all of this?
Well, there's going to be some employees that are going to probably try to take advantage of the situation. And in some employers' views, there's going to be some irrational fear by some employees. But employers may want to err on the side of caution. The situation is very unique, and individual perceptions of risk are very, very different. Also, there's no case law that provides you with the exact guidance on what is appropriate, which means that it's also unclear how decisions are going to play out in the future. Overall, the situation is so unique that employers should be flexible in how they manage the employee request for accommodations.
Anyways, well, this is really interesting. So we know now that employers need to put together general policies that are going to help employees come back in a safe workplace. We also know that employers have to expect individualized accommodations to help people who may have particular vulnerabilities because either they're immune compromised or other issues, and also may, in addition, have to accommodate their employees who have family status issues such as taking care of kids or elderly parents, and how an employer accommodates that through the Human Rights Code is highly contextualized. This has been really interesting. And I'm looking forward to our next two parts of the series. The next one being how to test for COVID-19 to keep it out of your workplace. And the third being what do you do when an employer refuses to either come to work or to comply with the policies. That'll be really great. Thanks, guys. It was great speaking with you today. So long.
Thanks, Jonathan.
Take care.
Jonathan.